No man gets with a lady. That's just off the chart, especially someone who's pregnant. Shame on them. All right, we are awaiting a jury verdict on the case of the state of Texas versus Horatio Trevino. We're going to take a plea hearing this time. I don't have. His file. And there we go. Thank you, madam. We got two cases. What are we going to do on these?
Dismissing the harassment charge, which is cause 235. Got a plea on 2114, which is the aggravated assault with a deadly weapon.
24 CR 2114 is called the state of Texas versus Deman Sergeant Jr. That is you, present, with your attorney and the state's attorney. Does the defendant waive Mr. Lodge, waive a formal reading of this indictment and arraignment? Can we proceed?
No waived, Your Honor.
In summary. In summary, then, this indictment alleges, sir, that on or about September 25th, 2024 in Jefferson County, Texas, you committed a second-degree felony of aggravated assault with a deadly weapon. Do you understand what you're charged with here, sir?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. And there will be terms and conditions of probation, which are normal and customary for this type of offense.
Hopefully this is misunderstanding.
Do you understand this as the agreement?
That's quick.
If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney. Are the contents true and correct?
Yes.
Yes, they're correct. You have to speak out.
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection.
Correct.
It's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived.
Yes, Your Honor.
I am going to follow this agreement and find you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer or postpone any finding of guilt so long as you follow terms and conditions of probation, which are normal and customary for this. You will be placed on probation for 10 years. That can be shortened to 1/3 for good behavior and following the rules. You will be fined $500. And what is now the relationship? Do you have any relationship with this person?
That's just the mother of my child.
Just the mother of your child.
Yes, sir.
That's no little thing. That's important. So how are we going to work this out? How do we do this?
There needs to be no contact. And as far as dealing with the child, they'll have to make arrangements through a third party.
That's understandable. What is the name of the victim?
I have a name. That's right.
And Judge, with the no contact, we understand, will he be released today?
Well,
Here.
we're going to deal with that just in a moment. There will be conditions of probation. Now, what concerns me, and I'm looking at this probable cause affidavit, is that I don't have a pre-sentence report. I probably ought to order a post-sentence report to look into conditions of probation, which are normal and customary. But the point of the matter is that jumps out is he assaults this lady who is the mother of his child, but she is 5 months pregnant at the time.
That's the child he's referring to.
Okay, Turner was 5 months, or okay, but she has been assaulted by her boyfriend, Deman,
That child was born after this
who
offense.
is 5 months pregnant, advised that the assault started. Say that again, man?
There's no other child. He referenced a child.
Oh,
The child was
okay.
born after this event, Judge.
Okay, but the victim was 5 months pregnant.
Yes,
Oh, okay, that's the
Yes,
point
sir.
I'm making.
I'm sorry.
Yeah. First of all, it's inappropriate to assault anybody, much less someone who is 5 months pregnant. I mean, that's pretty low. No gentleman, no person should ever do that. That's just off the charts of appropriate behavior. And you knew the lady was pregnant, didn't you?
Yes, sir.
And Your Honor, it has been some time since that offense, and he has not had any behaviors like that since then.
Your Honor certainly can choose to.
What's in the past is never really in the past.
So,
That's a famous saying. And the fact is that what occurred, just like when we have trials here, what we do is we have to relive what happened before and figure it out. I'm going to ask for a post-sentence report. We'll come back. We'll get some more information because it's limited in the information I have, except for this 1-page probable cause affidavit.
Do you want to make it a pre-sentence and just
No,
withhold?
he's going to start on probation.
Okay.
I don't want to, so that there are terms and conditions of probation, which he's going to have to abide by, and he is responsible for it. Again, if you fail, your probation can be revoked. You can be found guilty and sentenced up to 10 years in prison. Do you understand?
Yes, sir.
All right. Please tell the jury we're going to need just a few minutes. Thank them for their patience. Thank you.
Yes.
And you shall also, you will be required to complete this batterers intervention program, which is normal and customary for this offense. And
it's wrong.
no man gets women, a lady. That's just off the chart, especially someone who's pregnant. Shame on them. Especially pregnant with your child. Shame on them. All right, we're going to come back. When can that post-sentence report be done?
Do you want me, we can expedite it if you want us to.
Yes, ma'am.
Okay.
About how long would that take?
We usually take them, it's usually about a month before we do them, but if you want us to do it earlier, we can.
If I reset this for 4 weeks, is that good?
Absolutely.
Thank you.
And you'll be on probation until then?
He begins probation immediately when he signs this document.
Okay.
Yes.
So he'll be released.
Listen closely to those final words. Shame on them. That's not a judge talking like a robot reading a script. That's a human being reaching their breaking point. That simple, sharp condemnation cuts through the monotonous rhythm of the court. It's a heavy, uncomfortable truth. We spend so much time focusing on the legal outcome, the 10 years, the probation, the fines, but the judge is stripping all of that away to address the morality of the situation. It's a stark reminder that while the system might allow for probation, the stigma of this action remains. The probation starts today, the defendant walks out, but the true sentence? That's the shame. It's a haunting way to end the hearing, leaving us all with the heavy realization that while a gavel can make a ruling, it can't erase the damage done to that family. Justice was served on paper, but has it really been served for the victim?
I'll recall cause number 25 CR 706, the state of Texas versus Shelby Brooks Smith. who is present with her attorney, Mr. Kimler, and the state's attorney. We are here for sentencing in this case, and a pre-sentence report has been prepared by the probation office. Have the parties had an opportunity to review it? Any corrections or changes to it?
No, Your Honor. The only thing I'll observe, this is just based on what the conversation that is had,
Yes,
sir. I think the police units were not the clearly marked Beaumont type. They were the blacked out type, the undercover type of vehicles. They were displaying flashing lights though when she was evading them, but she panicked and wasn't sure. And I think they probably conducted surveillance of the residents and initiated a traffic stop. That appears to be, based on my experience, what occurred. And then she panicked, I guess, and didn't stop because you had heard bad things, I guess. But anyway, it wasn't just like I don't know if that's reflected in the report, but we could probably.
It states according to the police report here, version that's part of the pre-sentence report, the vehicle turned northbound onto 13th Street, disregarded the stoplight at 13th Street at Calder, which is a major intersection.
There's always going to be traffic infraction.
Detectives activated their audible sirens on their vehicles, but the vehicle continued to flee, turned northbound
Let's see, it says detective.
11th Street and continued to disregard multiple traffic lights
Yeah,
before turning into Luby's.
it says
Okay.
detective, so, and it doesn't mention clearly, so it's probably blacked out. But I'm not trying to absolve her of anything.
What is she
just saying
guilty
it's-
to?
If she pleaded
Oh,
guilty, she
okay.
should have stopped,
Wow.
but
I understand.
it was a blacked out vehicle.
Okay. The agreement is whatever sentence shall not exceed a cap of 5 years in prison. We went over through the different options, 3 options. All right, I think the state had made its comments from the defense. Anything Mr. Kimler or the defendant want to add?
Yeah.
From you, Matt? Okay, I'm going to find then that the pre-sentence report is part of this record for all purposes. In this case, recommendations by anybody, state
I think
and or defense?
I'll stand on mine, Your Honor. I think this is a third, I would say deferred. That would expose her to 10 years and then she's revoked. As it stands now, the most she could get would be 5. That increases her exposure and will be incentivized her to comply with the terms and conditions of probation, including the moral recognition therapy program. I do believe she's
Hold on,
she's
Dex.
a suitable candidate for
Okay.
rehabilitation, given the existence of that program and the other programs available with probation. As I said, Your Honor, if you place her on deferred, that would increase her, it would basically double her exposure from 5 to 10 years.
All right. State.
Judge, when I look at the number of infractions she's had, plus she's had a 5-year probation revoked before.
Well,
Then,
for that the court pointed out that was revoked shortly after she was charged with this new.
Yes, sir, commits this offense while she's on probation.
The offense occurred. The date of the offense was 2021. She was placed on probation 2023, 5 years probation. Then on 8/9/23 is when she was placed on probation. On November 12th of 24, she was indicted with this offense, which I'm sorry, it is alleged in the indictment dated June 11th of 2025 that she committed this offense on or about November 12th, 2024. So she was arrested on that day. And then based upon that, then motion to revoke probation was instituted, and then her probation out of Orange County was revoked on February 12th of 2025, 3 months after she was indicted for this offense of evading arrest, and she was sentenced to 18 months in the state jail for that offense of illegal possession of a controlled substance.
Yes, sir, just to make it clear, the detectives notified a uniformed officer in his patrol vehicle that she was leaving and that they were just, and he activated his lights. That's
Okay,
what
I
was,
wasn't sure. What did you see behind you? When you were fleeing, what was behind you that you saw?
How much time did you say?
Well, I had pulled over the first time. I had pulled over I had stopped when, pulled over behind that church right there. I had stopped and I looked up in my lights. It looked like a regular vehicle looked up in my rearview mirror, it looked like a regular vehicle with cop lights is what it looked like.
And then you took off.
So then that's when I took off, yes, sir. But then I stopped again at Libby's. They didn't have to, I mean, I'm not saying it's okay, but, I feel like it was a more open area. You know what I'm saying? I was in fear for my life is what had happened. Is really what
When
happened.
you pulled over at Libby's, was it a marked Beaumont police unit?
They
Still in.
they didn't, all I saw was undercover units. So.
and when they were trying to get her out of the car, she began to fight, struggle, and try to get away to run. And so I'm just not buying the story.
Is that accurate?
I didn't fight to run.
Was it dark,
I don't believe so.
ma'am?
I don't believe so. Is it probably about getting the, route?
Dusk?
Yes, sir. There we go.
Okay. What else?
That's all.
And are you representing her on these Tyler
Yes, sir.
County? Okay. And those have not been disposed of.
They're gonna follow what the court does. That's in talk with the district attorney up there. If the court gives her probation, I can get her probation up there.
Okay.
The last reset up there was the city.
I'll remind the court that not only did she struggle, but she had all that paraphernalia in her car from other people that just, she was running for a reason. It wasn't that she was scared.
Anything else
Rearrest.
you would like to add, ma'am? Nothing else?
Whatever you want.
I would really like to get a second chance to try and do probation because
Well, hold on. You got a second chance when you were placed on probation in Orange County. Yeah. I mean, you're talking about second chance in this case, but you were on a dry run out of Orange County to see how you would do on probation. That was it looks like your first opportunity to be on probation ever. And see that you also picked up on that date, March 14th of 21, illegal possession of a controlled substance, a misdemeanor as well as a felony. And that misdemeanor was 77 days in jail you were sentenced to. And then there was it must have had more than one drug, a more serious drug and a lesser serious drug, but both were crimes. Then you were placed on that 5-year probation and then revoked in 2/12 of 25, which was just a few months after you were indicted for this offense. All right, if nothing further, I'm going to find the defendant has pleaded guilty in this case voluntarily. She's mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in this plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years, and you will be given credit for all time you have served, which isn't much. But you have these other cases.
Yes.
And that is going to run on its own, and then you'll see what those other cases do.
Thank you.
All right, that is on.
I'll see you at the time.